Welcome to This Explainer. Let's jump right in today, because we're exploring a totally fascinating and honestly fundamental tension that's built straight into the modern workplace. On one side, you've got capitalism, free markets and competition, right? It's the basic right of an individual to better themselves economically and maybe start their own venture. But on the flip side, we have an employer's absolute right to receive faithful, honest, and fair service from the people they're paying. And as you'll see, these two concepts collide all the time, creating what courts actually call the common law duty of loyalty.
So, let me ask you this. Can you legally prep for your next big gig or even start organizing your own competing business while you're still employed and officially on the clock? It's a massive question that millions of ambitious professionals, maybe even you, ask themselves at some point. You might think, hey, I have the right to free enterprise, but your boss, well, they expect your undivided dedication. Balancing these two things is literally a high-stakes tightrope walk.
Legal scholars and courts frequently point out that this is an ever-gray area of the law. And they hit the nail right on the head. The line between legally preparing for your future and illegally competing against your current employer is notoriously murky. It's highly dependent on the specific facts of your situation and even the state where you live. And if you step just an inch too far, the legal consequences can be absolutely catastrophic.
Okay, let's dive into this. Here's our roadmap for This Explainer. We're going to start with the implied duty of loyalty, contrast mere preparation with active competition, navigate through the biggest danger zones, see what happens when employers strike back, and finally, leave you with the ultimate survival guide.
Starting right off with the baseline rules that govern all of us, regardless of rank, salary, or contract status. Section 1. The implied duty of loyalty.
Here's the real kicker. You don't actually need a written employment contract to be bound by this duty. It is entirely implied by the common law. So even if you're just an at-will employee, meaning, you can be fired at any time, you still owe this duty to your employer. While you're on the payroll, you must discharge all of your duties solely for the benefit of the employer. You can't act in some self-serving way that goes against their interests, and you definitely cannot accept secret, undisclosed payments from third parties.
Now, courts basically look at these relationships in a hierarchy. If you're a standard rank-and-file employee, you owe that generic implied duty of loyalty we just talked about. But if you're an agent, say you're a president or a high-level manager who stands in the shoes of the company to make major business deals, well, then you owe a strict fiduciary duty. A fiduciary duty is this relationship of ultimate trust, confidence, and good faith. Basically, the higher up the corporate ladder you climb, the stricter your legal duty becomes. And trust me, the more severe the penalties are if you breach it.
Which brings us to the core tension of our whole discussion. Section 2, preparation versus active competition. This is where things get really fascinating.
This is where courts definitively draw the line. It is perfectly legal for you to make mere preparations to compete before you quit. You can organize a new business, file your incorporation papers, open a bank account, maybe secure some office space. That's all fine. But the very second you cross over into active competition, you are violating the law. You cannot use your employer's time, their facilities, or their proprietary information. And you absolutely, under no circumstances, can divert their existing clients to your new firm or sabotage their operations.
Let's ground this in a real-world example to see how these abstract concepts actually play out in court. We'll look at the Novartis case. So, get this. In this case, an employee agreed to devote her best efforts and full business loyalty to Novartis. But secretly, right from the very beginning of her employment, she and her husband jointly owned a sub-S corporation. And this corporation collaborated with other pharmaceutical companies that were in direct competition with Novartis. She billed hundreds of hours to these competitors, all while cashing a full-time salary check from Novartis. Yeah, the court quickly ruled against her. They found she impermissibly competed, completely divided her loyalty, and financially harmed her employer by siphoning off the time she owed them.
But setting up a competing business isn't the only way to land in hot water. Let's shift gears to Section 3, navigating the danger zones.
These are the specific, major pitfalls that catch employees off guard. First up, soliciting coworkers. If you recruit your colleagues to jump ship and join a competitor while you're all still on the payroll, huge breach. Second, stealing customer lists. If you compile a digital database or print out a proprietary client list and sneak it out with you, that is highly illegal. And third, and this is a huge trap today, criticizing the employer. Even indirect competition or a careless social media post can trigger a massive legal breach.
To really understand the gravity of that last point, criticizing your boss, let's look at another famous case study, Marsh versus Delta Airlines.
A Delta customer service agent was really upset about the company's labor practices, so he writes a letter to the editor of the Denver Post, publicly criticizing the airline for hiring hourly contract workers to replace full-time staff. Well, Delta fired him for it. The employee sued, but get this, the court actually upheld the firing. The judge noted that publicly criticizing your employer, even just in a newspaper letter, completely severs that implied duty of loyalty. Unless you are actively blowing the whistle on a public safety hazard, dragging your company's reputation through the mud is a direct breach.
So, what happens when you clearly cross that line? Section 4, when employers strike back. Because the legal remedies that companies can unleash, they can be financially devastating.
Let's translate some of this dense legal jargon into plain English, because it brilliantly illustrates just how severe the consequences can be. Employers can sue for breach of contract to recover their lost profits. They can go after tort damages, which can actually include punitive fines specifically designed to aggressively punish malicious behavior. They can also seek equitable remedies. That means things like an injunction to legally freeze your brand new business in its tracks, or a concept called replevin, which literally forces you to hand wrongfully taken property back to your boss. But honestly, the most dramatic remedy of all is forfeiture.
Forfeiture is based on agency law's faithless servant doctrine. If a court deems you a faithless servant, they can force you to disgorge, meaning pay back, every single dollar of salary you earned during your period of disloyalty. Take the Blackbird tech case. An employee secretly built a competing internet search business while working for Blackbird, using their proprietary source code. And how did Blackbird find out? The employee unbelievably posted a YouTube video showcasing the stolen tech. No way, right? The court instantly granted an injunction to shut that employee's new venture completely down.
With stakes literally that high, you need a safety net. Let's wrap things up with Section 5, the ultimate survival guide. These are actionable takeaways drawn straight from the courtrooms.
First up, the defensive playbook for all you employers and business owners out there. Do not rely solely on the implied common law. You need to use non-disclosure agreements and reasonable non-compete clauses. Second, always include works for hire provisions in your contracts so your team knows that all intellectual property belongs to the company. Furthermore, if you do end up in a lawsuit, try to frame those breaches as fiduciary duty violations that unlock stronger tort damages. And finally, clearly label your trade secrets and customer lists, limit access to only the people who absolutely need them.
Now, what if you're a rank-and-file employee dreaming of safely starting your own venture? Patience is for sure your best friend. Wait to actually compete until after you have formally resigned. Absolutely do not solicit clients or coworkers while you are still cashing your employer's checks. Check your existing contracts for non-piracy or non-compete restrictions. And honestly, because this is such a fact-specific, state-by-state gray area, always seek independent legal counsel before launching a business that directly rivals your current boss.
Which leaves us with one final, pretty provocative thought to reflect on. As you plan your career moves and chase those entrepreneurial dreams, you have to ask yourself, are you walking the line of free enterprise, or are you crossing into disloyalty? Knowing exactly where that line is drawn isn't just a professional choice. It's absolutely the ultimate key to your legal survival in the modern workplace.